This is the second video for Chapter 6. We're going to pick up with the state court system. First, we're going to talk about the trial courts. So, trial courts, obviously, by their name, are the courts where the trials are held, where testimony is taken. There are courts of general jurisdiction and courts of limited jurisdiction. We've talked a little bit about what that means. General jurisdiction means that they can hear multiple types of cases. They hear domestic relations, they hear civil cases, all civil cases, they hear criminal cases, many different types of cases. They hear evidence and testimony. They are recorded for future use. That doesn't necessarily mean a video or audio. That means that, we've got a court reporter there who's taking down everything. Limited state courts are going to hear specialized cases. That's your juvenile court, your probate court, your municipal courts, your small claims. They hear very specialized types of cases, and they are seen as inferior trial courts or minor courts. So then the appellate courts in the state court system. It depends on population whether or not a state court system has an intermediate appellate court. Here in Georgia, we are like the federal system in that we have a three-tiered system. We have the trial courts and those lesser courts, the intermediate appellate court, which is the Georgia Court of Appeals, and then the Georgia Supreme Court. Some states, their population is not such that they need that three-tier, and they just have a two-tier and go from the trial court and the lower courts to the Supreme Court or the court of last resort for that state. One of the big things that you need to establish, because it'll be talked about throughout the program, are issues that are questions of law and questions of fact. Appellate courts will only hear questions of law and not questions of fact. What's the difference? So let's say that we had a personal injury case. It's an automobile accident, and at trial, the jury believed the defendant and not the plaintiff. They believed the defendant when the defendant said, no, it was the plaintiff who ran the stop sign. So to the jury, the defendant was more credible than the plaintiff. They believed him over her. Okay? That is not something that we could appeal. That's a question of fact, so it cannot be appealed. But let's say that in court, the plaintiff attempted to introduce into evidence the defendant's prior driving record. And let's say that the judge ruled that was not admissible. And now, once again, the jury believes defendant and plaintiff loses, and now plaintiff wants to appeal. Well, the fact of whether or not the judge was going to let in the defendant's prior driving record is a question of law. Was the law applied correctly? So that's something that could be appealed. It's a question of law. In states that have the three-tier system, they'll have an intermediate appellate court that's going to review cases on appeal from the trial court or the lower court. And no new evidence, no new testimony. They're going to review the record from the lower court. And then those states that have the three-tier system, their highest court, their court of last resort, could hear appeals from that intermediate appellate court and some certain trial courts. Here is a structure for I think this is the flow chart that is actually in your text. It shows the state Supreme Court, then the intermediate appellate court, and then the state court of general jurisdiction, and that might be divided into these different parts: a civil division, a criminal division, and then those lower courts. So this is a diagram from a state that has a three-tiered system. So the last part of this chapter discusses alternative dispute resolution. You might just hear it referred to as ADR. Litigation is extremely expensive. Okay, it is, as we've discussed before, adversarial. So we've got conflict and we're going up against one another. You know, it could be brother against brother in an estate issue. It could be neighbor versus neighbor. You know, it is something that could damage relationships. It's also very time consuming. So we have this alternative to litigation. It's called ADR. And why would we want that? Well, it's more flexible, and about 95% of all cases get settled without going to trial. And usually it's through some form of ADR. We're going to talk about those different forms. Several courts, both federal and state, have implemented ADR programs within their system. You can get ADR services over the internet, and at least in Georgia, there are types of ADR that you don't have to be an attorney. If you've gone through the particular training, that qualifies you. So we'll talk about those as well. So one of the things that you're going to evaluate, the legal team's going to evaluate when a new client comes in or a new issue comes up for an existing client is, you know, do we want to go to court? Is this something that needs to go to court? Is it something that we could otherwise settle? The first one we're going to talk about is negotiation. That's a form of ADR, a form of alternative dispute resolution. And just about every case that has ever gone to court, there has been some level of negotiation. Obviously, if it went to court, that negotiation wasn't successful, but there was some level of negotiation. And that's why 95% of cases don't go to trial. Negotiation could be between the two individuals that are involved in this issue, or it might be between their attorneys trying to come up with a mutually acceptable course of action for both parties. And if we are able to do that, we as the attorneys will produce what's called the settlement agreement. It's going to be a contract where we're going to put down on paper what we have agreed to, or what the two parties have agreed to, how they've agreed to resolve this issue. The next is mediation. It's a non-adversarial forum. Anybody can be a mediator if you go through the training. Doesn't have to be an attorney. Some of the characteristics of a good mediator are they're good listeners, organized, they quickly can comprehend facts and analyze a situation. They have good communication skills, writing and verbal. In the state of Georgia, if you have a contested divorce, before you can get a trial date, you have to attempt mediation, attempt to try to settle your issue. um, that being said, it is simply an attempt to mediate. You don't have to come up with a resolution, but you have to attempt to mediate what are the sticking points for your particular issue. Before we go into arbitration, let me say a little bit more about mediation. It is going to be conducted by someone. As I said, it doesn't have to be an attorney, but it needs to be some third party who is going to facilitate these two parties in their discussions and try to move them in the direction of a settlement. So this next is arbitration. We're kind of moving up the scale of ADR. Arbitration is a little bit more formal. It means that a third party is going to make a decision about this issue. And arbitration could be binding or non-binding, meaning that if it's binding, then we're going to have to adhere to whatever that third party decides. It is usually similar to a trial in that, you know, the arbitrator is going to hear both sides and make a decision. What's interesting about arbitration is that a lot of us have exposed ourselves or made ourselves subject to arbitration in our relationships, and sometimes we don't even realize it. For example, you know, when you accept the user terms for a particular, let's say, application on your phone or software that you bought, and you read that user agreement, which, you know, do you actually read that user agreement? There usually is a clause in there that says if a cause of action arises from this relationship that we're establishing, then it has to go to arbitration, whether it says binding or non-binding. If you, one of the cases that I have in my healthcare law class deals with arbitration. The employer's employee was injured, had a personal injury and medical malpractice situation, but the employer had negotiated with the insurance carrier that in cases of medical malpractice, there would be binding arbitration, that the injured party could not file an action in civil court. And, you know, the employer had the contract with the insurer and not the employee directly. And so by accepting the employer's health insurance plan, the employee had subjected themselves to that arbitration clause, and it precluded them from filing a medical malpractice action in court. They had to go to arbitration. So, you know, there's lots of situations where arbitration is the final result. There is no appealing out to the traditional court system. There's several other types of ADR. You have binding mediation. You have mediation arbitration. That's a hybrid of mediation and arbitration, obviously. You have assisted negotiations, many trials where some neutral third party, you know, we conduct a trial and then they are going to advise us. Collaborative law, that means when we're working together to craft an agreement, negotiation, mediation are types of collaborative law, and the attorney is only focusing or only involved in the drafting of a settlement agreement. As I said, there is court-referred ADR where the court either recommends that the parties go through ADR, or it is required in order to move forward in the court system. There are also summary jury trials where both parties put on their case and actually have a jury that's been hired to hear the case, not binding. The verdict is a guide for the two parties, and usually it brings them to some settlement when they see what each side has in their case. You can go or access ADR services. Sometimes it's in a governmental agency, sometimes through a private organization. In Georgia, ADR is administered, or the providers are administered by the Office of Dispute Resolution. So in order to become a mediator or an arbitrator, you have to apply to that agency and be approved after you've had the required training. You can also contact the American Arbitration Association to look for arbitrators. Sometimes you can get retired judges to act as arbitrators. So, there are lots of resources when it comes time to securing an ADR professional. As I said, there now is online dispute resolution where you can get mediation, arbitration, negotiation done over the internet, which in this pandemic world that we're living in, that certainly is a way to keep the cycle or the circle going, keep the process of litigation and ADR moving through these online providers.